various, I'm glad we have the DPPs from the regions that are also present here. They had a meeting up here, so I'm glad you're able to be with us here. The DNPPs, our EXCO team, Advocate Johnson, colleagues from the NPA, ladies and gentlemen, thank you very much. I'm very excited about this engagement or roundtable with the media, as Phalaphala said. It's a conversation we want to share with you. This journey, let me put it that way, of the past 5 years in the NPA. Let me say that it has been, when I think back about taking office on the 1st of February 2019, and 5 years down the line, you know, what did I expect as National Director that we will be here as the NPA? And let me say there's two aspects to this. On the one aspect, in terms of rebuilding the NPA and how far we've come in terms of turning this huge ship around, the NPA, which had come out of the trauma of state capture. There's no other way of putting it. When I think of what we've achieved to rebuild this institution, in not 5 years, in actually 3 years and a little bit, and why I say 3 years and a little bit, is because the first 18 months after the appointment of the National Director, current, nothing changed the NPA except the NDPP. It was only in June of 2020 that Advocate Babaji, Rasitava, and Advocate de Kock came in as Deputy National Directors. And before that, for 18 months, you have only the National Director trying to understand what's going on in this fractured organization with very little budget coming out of the devastation of state capture. 2020, and Advocate Anton Duplessis only joined us in March of 2021. So in March of 2021, we had finally the full leadership in place, and where we could really, and he heads up the strategy, operations, and compliance part of the NPA. And so we could really start properly as a full leadership team at national office, start thinking about this rebuilding process. And so what we've achieved in that just over 3 years, in terms of rebuilding, is nothing short of remarkable. The NPA now is a well-run constitutional entity. We have a solid strategy, and there's many incredible things, strategic initiatives that I'll talk to you about that have been put in place that puts the NPA firmly on track to deliver to the people of this country. But what I can say is that one area where perhaps I thought we would have moved much faster, and I mean much faster, because when I came back from the ICC, the International Criminal Court in The Hague, I knew that the challenge, well, I had a sense of it. And I thought, how difficult is it going to be to get one really good big corruption case that's going to swing sentiment around very quickly? I was really quite wrong about that. And so insofar as state capture related cases, let me put it that way, because there's lots of other corruption matters that are in our courts. The DPPs are here that have been dealing with these cases. There's lots of cases, and I have the stats, I can deal with that. It's only with regard to state capture cases that I thought we would have been further down the line. For everything else in the NPA, I'm incredibly proud of what we've achieved and how far we've come since the new leadership took place, since the new leadership came. So in May 2019, when I first addressed the media, just about 3 months into my term, I then committed to dealing with the following things, and I'll just read out what I said then. Addressing the leadership crisis of the NPA, conducting a review of high-profile cases relating to decisions to prosecute or not to prosecute. There were certain state capture-related matters. Reviewing the structure of the NPA, securing sufficient budget for the NPA, and expanding its partnerships, managing cases relating to state capture, creating the ID, stakeholder management, strengthening the morale of and empowering staff, and finally instilling the value support of our so-called IPAC pillars, IPAC, standing for independence, professionalism, accountability, and credibility. And so that is what I committed to as a National Director in 2019. And we've been working really hard at doing this. But before I talk about that, let me say that in the past 5 years, the global landscape has changed dramatically. We are now in a situation where the geopolitical environment globally is deeply troubling. We have wars being waged in parts of the world. We have possible crimes against humanity, war crimes being committed in parts of the world. And globally, things have changed. We had COVID that hit us in this 5 years. And as a country, we are a country under stress. Let's be frank about this. If you think about what's going in our country today and how things have changed, in the past 5 years, we are working in an environment where it's a very, to say the least, a complex political environment. We have a country where we have load shedding, we have the poorest and the most vulnerable that have, are without basic amenities. We have a country that is wracked by the highest levels of various types of crimes, whether we talk about sexual and gender-based violence, various types of organized crime, whether it's infrastructure theft, whether it's wildlife crime, environmental, the construction industry. We have an increase in kidnappings, assassinations, hits on whistleblowers, SGBV, increase in femicide matters, teenage pregnancy, a scourge in our country, destroying the lives of our young girls and children, many of them under 12. So we are a country under tremendous stress. And it is in this context that today I'm going to speak to you about why, as the NPA and as a country, we can't give up hope. That we have to, in the context of this very, very complex environment, that we have to keep fighting the good fight. And that we have to, as the NPA, being a vital constitutional entity in the rebuilding that will contribute in the rebuilding of this country, why we have to keep fighting the best way we can, and we know. It's not been easy. We've been in the past 5 years really hard at work, under a lot of pressure. Let me say, the pressure on me as the national director, and then on the team, on the DPPs, on the various regional heads across the country. But the pressure as the national director, I could feel it from day one. But that's fine. That's what we signed up to. And that's what we are here to do, is to deliver on the mandate of the NPA. But in the past 5 years, it has been unrelenting, mainly with regard to state capture. But in the middle of all of this, we've been doing incredible work in trying to, as I said earlier, turn the ship around. And I just want to mention some of the things that we've done over the past 5 years. Firstly, we've stabilized the leadership of the NPA. You see people on this podium here today, on this stage, who I will put my head on the block, are the people of the highest standards of integrity, who will do only what the Constitution and the rule of law demands. You have an NPA leadership here before that the people of this country should be proud of, that is not beholden to anyone. We're not beholden to politicians. We're not beholden to big business. We are beholden to rule of law. And every one of them have made sacrifices to do the job. When I approached Andrea to take on the job, she said no, she didn't want to do it. And I had to say to her, please go back, think about it. There were various reasons she gave me. But in the interest of fighting the good fight, she finally agreed to take on this position. You know that Anton du Plessis gave up the job in the UN to come back to fight the good fight at a considerable reduction in his salary. Advocate Rabaji Rastava was in the private sector. I called her back, also made incredible sacrifices to come back. She was in the AFU, someone may not know, some of you may not know. About 20 years ago, Omar, with Willie Hofmeyr in the early days, she came back to lead the AFU. And Advocate Rodney de Kock, I think, made the greatest sacrifice. Who comes from the Western Cape to Pretoria? And then with all kinds of financial and personal sacrifices The reason why I say this, colleague, is not to sound like martyrs, is only to say that you have a team here that are only interested in doing and in fighting to turn this country around. So we've stabilized the leadership. We've increased staff capacity and capability, and Anton can deal with figures and things like that later if we need to. We conducted a capacity review exercise in order to inform our capacity building and training initiatives. We partnered with civil society, the private sector, to secure specialist skills that we need in certain high profile and very complex, particularly corruption related matters. We've collaborated with international experts in various contexts, particularly with asset forfeiture, and we can talk to you more about, I'll mention a few things about our really bold asset forfeiture, asset recovery strategy. We've collaborated with, we've engaged more, I'd like to think we engaged more with the media. I don't think that there's any prosecuting authority in the world that speaks to the media as much as we do. I mean, I'm on the International Association of Prosecutors Forum, and they are quite surprised at how much we engage with the media in South Africa. But I think it's a good thing that we do. We've established the Office of Ethics and Accountability in the NPA. We've developed a forward-looking organized crime strategy for the NPA, but working together with our partners in law enforcement and our key JCPS stakeholders. We have a very innovative community prosecutions initiative as well. And we can talk more about that if you are interested in other things besides state capture. We have really, colleagues, members of the media, I want to stress, we have really focused a lot on building the NPA into a strong institution. Once more, and I say once more because the NPA was once a strong institution. And I can say now that we've come a long way down the road to do that. We've been doing a lot of work in the background. Work that is really, it doesn't make the media because good news rarely sells. And it's actually not that interesting. But it's really important work. And I want to quote from Judith Yukoff, I hope I got the name right, a Nigerian journalist who was writing for the African Leadership magazine and said the following: history has shown that only through strong institutions can a solid foundation for nation building be established. Without a doubt, strong institutions are a prerequisite for a society to move towards sustainable prosperity. Building effective, accountable, and inclusive institutions is painstaking work, though it is vital. Institutions can and do play an important role in reducing poverty, improving the rule of law, and increasing economic growth. Devastatingly for our country, those involved in state capture did not appreciate this and had perhaps a different view on this. And now we are working really hard to turn that around. All of that said and done, colleagues, members of the media, make no mistake, we hear the deafening calls for accountability. And even in this space, we will deal with state capture. Even in this space, we have made notable progress, whilst recognizing that a lot more needs to be done, and a lot more will be done. In fact, if you recall, just 2 years ago, in 2022, Advocate Andrea Johnson was Daily Maverick Person of the Year because of the work that was done in that space. It's very quickly forgotten. Some of the initiatives that we've embarked on, the corporate alternate dispute resolution directives that were issued, and we published them just last week. This is one of the most important and accountability mechanisms that we have actually introduced in the NPA. And it's not something that we just woke up one day and drafted this document. Advocate Rabajita Stawa has been leading this process and working with renowned international experts. This is an international best practice to enhance accountability in any country. It is an accountability mechanism. And it is important to understand that the purpose of this is to, one, to encourage corporates to self-report so that they can pay back damages that they've caused to a country. We're looking at various ways, even working with certain NGOs in terms of how we become more accurate at calculating that, but I won't go into details. That's the first thing. And the second thing it actually helps accountability and prosecutions. Because what it does is the corporate involved commits to actually assisting law enforcement and the NPA or the ID in providing evidence that can result in prosecutions of directors of the same corporate. So I want to make it very clear that even though the corporate is the one that actually is not prosecuted, directors in the corporate are not given any kind of amnesty at all. And the corporate assists us in building a case against them. And so this is really, really important. And it was disheartening that when such an important international good practice is put out there are still some doomsayers who say, well, the NPA now has this because they can't prosecute. And that is most unfortunate because this is a very, very important initiative. So in order to address corruption, there's a two-pronged strategy: prosecutions and accountability and orange overalls, and bringing back the stolen money. And so before I talk about what we've been doing in those two areas, let me firstly say that the one big difference between what was the position 5 years ago and what's the position now, and I want to take time so that I don't go too far over, we do want to engage with you. The one really, really important factor is that impunity is no longer a given. And the Steinhoff matter shows that, even though it might take long, and I say long in inverted commas, right? I say long because the German prosecuting authority, a much better resource prosecuting authority, brought the case 1 year before the South African authorities did. And so even though the arm of the law might be long, it catches up. And so the big difference is impunity is no longer given. And those that have been dabbling or those that are involved in corrupt activities know, even though there may not be a knock on the door yet, that it will come. And that in itself, perhaps, is mental incarceration. And even when we do bring cases to court, then you have Stalingrad tactics that start. And so very often we hear, but you don't have people in orange overalls. It needs to be understood that once we enroll a case, it needs to move swiftly through the system so that we get to the end where you can say that a decision has been rendered by the judiciary. And that process in court is led by the judiciary. And we've been engaging with the Chief Justice, with various judge presidents, to see how we could actually fast-track cases through the court system. Even as a relatively young democracy, South Africa, we are prosecuting former ministers, a former president of, premier of one of our provinces, Secretary General of the ruling party, a former president of our country, and also some of the most powerful CEOs and CFOs across the country, both in private sector as well as public. In the last 5 years, we have almost 700 government officials that have been convicted for corruption in the specialized commercial crime unit space. In addition, they've achieved, in 2023 and 2024, the SCCU achieved 329 convictions in serious and complex commercial crime cases, resulting in a conviction rate of 88.7%. The SCCU has enrolled 4 cases related to 16 recommendations in the Zondo Commission reports. And it includes the asbestos case and the SA Express matters. And several other matters in this space will be ready for enrollment in the coming months. We've established partnerships with law enforcement agencies. there have always been partnerships, but particularly under the very able leadership of Advocate de Kock and Advocate Ravajila Stava, we have really cemented these relationships, particularly in the context of implementation of the Zondo Commission recommendations, as well as in the context of FATF recommendations, which we are really doing our best to try to ensure that South Africa is out of the grey list within the 2-year period, and I think that is 2025 February. Okay. The investigating directorate itself, the ID has declared 103 investigations. They've enrolled 37 cases involving 208 accused persons as of January 2024. And this, I must emphasize, in a context of a legal framework that is very weak and without all the resources that they need. And Andrea can talk more about that. But we're certainly hoping that the ID bill will be on the president's desk very soon. I know he's in the presidency, and that we will have a permanent ID. And once that happens, I want to also caution that we will still need some time, but we will work with speed. Our HR colleagues, finance colleagues are all here to make sure that the ID has the capacity and capabilities it needs. But one exciting part about this is the presidential initiative, where business has come to the party, and once the bill is signed into law, will provide a state-of-the-art data forensic analytical capability exclusively initially for the ID, and that is potentially a game changer for us. The ID has also enrolled the case of the former Speaker of Parliament, and in this regard, I want to deal with some of the criticism we faced in the media, where it's been said that the Speaker received 5-star treatment in the way we tried to secure her attendance in court. This is completely wrong. I've been a prosecutor for almost 30 years, and many of the colleagues here are the same. In many of these cases involving white-collar criminals, you often make, as a prosecutor, we make arrangements with the lawyers acting for the suspect to bring the suspect to court. So this is not unusual, and we'll continue to do this. Although this certainly took us aback in terms of how things unfolded in court. But that is a normal practice in the prosecuting authority. The Cocoa matter was enrolled, yes, and the NPA has been heavily criticized for what happened in court. In fact, if you look at a lot of the criticism in terms of why people say the NPA is not able to do its work, it's primarily focused on 3 matters. And correct me if I'm wrong. Mainly, primarily, on the Cocoa matter, on the New Lane matter, and the Gupta extradition. On these 3 matters, many in the media wrote off the NPA. And the power of the pen is incredible. And I really want to urge the media to please be balanced in your reporting, because what you report on is so important in terms of what the people out there understand about various, about so many things, including the NPA and how we work. So these 3 matters they were huge setbacks for the NPA. But even when it became aware that it became publicly aware and was exposed, in fact, by the media, there was a conflict of interest by the magistrate concerned. That quietly died away. There may have been 1 or 2 reports that said, well, okay, perhaps the NPA didn't mess up that badly. But the Cocoa matter simply falls away, and then it's other matters. So let's just be balanced about that. That was a huge case, and it had a devastating impact on the reputation of the NPA. And we're looking at possible steps to take with regard to the conduct of the magistrate, as well as other legal steps. I'll perhaps just quickly, very, very quickly talk about, the Lune matter is an appeal, and the Gupta extradition matter, which you probably also asked me about. The deputy president and the minister will be, in fact, have already traveled to the UAE. And we have been trying very, very hard to find out some very basic things, like what was the problem with our extradition request? We've not had satisfactory responses from the UAE. We've been trying to set up a meeting with, I've never traveled to the UAE, but with regard to this case, set up a meeting with the National Director and the head of the Prosecuting Authority in the UAE in order for us to understand this. And I know him personally because of our involvement in the International Association of Prosecutors. We've not been able to schedule that meeting for months. Now we decided as the NPA executive that we needed the president of this country to intervene with the ruler of the UAE, because we realized that unless there isn't that strong political push in the UAE, we're going to struggle with this matter. So on the AFU asset recovery, as I said, there's a two-pronged strategy to dealing with corruption. The recovery of assets part of it. We've restrained and preserved more than 14 billion of state capture assets. 6.12 billion was confiscated and forfeited to the state. That means money in the bank. And 6.26 billion, which includes the ABB case, as well as the SAP case, has been recovered in total. And the corporate ADRM guidelines, which I talked about, we hope, working with international law enforcement authorities, including the U.S. Department of Justice, we're hoping that we will be able to recover a lot more. And we can talk more about asset recovery. And colleagues, asset recovery with regard to these big cases, corruption-related cases, is one thing. But remember, it's important that we disrupt criminal activities with asset recovery. And the AFU colleagues have been doing incredible work in the areas of organized crime, where if we're not able to get to the kingpins, you need to follow the money to get there. I know in the Free State, they've I think it's about 28 or 29 fuel tankers were seized by AFU in order to disrupt activities. I'm giving you some idea of how we can actually work, how AFU works in tandem with prosecutions in order to deal with corruption and other types of organized criminality. The AFU is moving very, very strongly on Chapter 6, and some of you will know that Chapter 6 of the Prevention of Organized Crime Act is non-conviction based forfeiture. And so we're really pushing to ensure that once the criminal cases come along and take longer, we're able to move quicker on Chapter 6 recoveries. Sexual offenses, under the very able leadership of Advocate Bonnie Curry-Gamble, the footprint of the Tutuzela care centers have been expanded. We had 55 TCCs in 2020, 2021, and we currently have 65 TCCs. And that is an increase of 10 in the space of 3 or 4 years. Understanding that from the time it started 20 years ago, we created 55 over that period. And so a lot of really good work is also happening with SAPS in terms of clearing the DNA backlog. I think since October 2020, we cleared the backlog of 46,045 DNA reports. And this has really been assisting in our sexual and gender-based violence matters. Also, we've identified a number of serial rapists through this project, and we are targeting those in order to try to have more impact in this area. The TRC matters, we've set up a specialist TRC component in 2021 to deal with TRC matters, and the police have also set up a dedicated capacity. They are currently overseeing 159 matters. 24 of these have been finalized with regard to a decision having been made. We have 34 dedicated TRC investigators from the CCI, and they are dealing with 137 matters in total. In summary, and to conclude, this part of it, just to say that, we are really working hard in the NPA to really leave behind an NPA that is one truly independent, professional, accountable, and credible. We're really working hard at ensuring that we we were together with the minister that we work on the NPA's financial and operational independence. We are looking at how we could actually ensure that we build capacities, capabilities, so that we really leave the NPA, one that is fit for purpose and that one that can rise to the challenges of the 21st century. Finally, I want to say, ladies and gentlemen, that the sad reality is that as hard as we try, and I want to give you my word, this is not going to stop us from trying. We are never going to be able to prosecute ourselves out of corruption, sexual and gender-based violence. There's a lot of work that needs to happen. It's a whole of society approach. We need various other role players. We need the regulators to be doing their jobs in dealing with those in their own professions that are not standing up to their requisite standard. We really need, we in the NPA can only be effective if we're part of a holistic strategy in order to deal with various crime types. So I want to really once again conclude by saying thank you very much to the media. I look forward to positive, constructive engagement, and hopefully it will lead to a better understanding on both sides. Thank you very much.
Thank you very much, Advocate, for that accounting. I have to say that it would only be the most churlish of media commentators or public commentators who wouldn't see the palpable reforms. As a journalist who's covered the NPA for all of the democratic era, I have to say there was a cliquishness, leaks to selected media during the era of state capture and the era two. It had been so clearly repurposed for capture. It was an opaque and closed institution. This time, I find myself reporting on something that's far more transparent and more open. I think the coming of better communications like the WhatsApp group means that we often have so much information that we can't really distill it effectively or get to all of it. So that's been very important to watch. As I've listened to you for the past few years, since you did the public interview and got your job, I often heard you saying, summarized as, we can't because we don't have various things. Have we now reached a time where you're able to say we can because we do have sufficient resources, sufficient independence, sufficient longevity, and that we're politically insulated from pressure, so now we can really, really get going?
I think I'll firstly say we can, notwithstanding that we don't have a lot of that. But we've come a long way, and that is why it makes it more possible. On the resources, Anton will speak more to it, but I do want to say that we have had very good support from the executive, from the Minister of Justice and of Finance to try to secure the budget that we need in a very, very fiscally constrained environment. And so we don't have everything that we want in terms of the finances, but we have, I think, more than other departments, and I'm not saying enough. I can't say the word enough, but I think sufficient to do a lot more than we have been doing. But Anton will talk to that. But that's on the finances. The ID, we've got a lot of support also to capacitate the ID, and we'll do that once. We'll enhance that once the ID becomes permanent. On the independence issue, well, we have, in terms of the Constitution, the NPA has a sufficient level of constitutional independence. And I want to say that in my term as a national director, there's never been a single time when either the minister or the president has even hinted that the NPA should or should not do something, or should do something in a particular way. That has never been the case. And I can say that this NPA truly is independent of the executive in that sense. But there's a lot more aspects to independence. The financial and operational independence is a big part of that. The minister did commit in the context of the parliamentary debates on the ID bill to introduce a bill into Parliament in January 2025 that will deal with the broader reform of the NPA. And if that is done, it will be a huge step forward, because this is something that for the past 20 years, national directors and ministers have been grappling with. I think perhaps Anton can talk a bit more to that. Which one is this? I'm not sure. This one?
Yeah, thank you. Thank you for that question. And
can you hear, colleagues? No?
Yeah, and good morning to I think the question on resources is an important one, because we need to see it in two ways, I believe. The one is, do we have enough money, enough fiscal allocation to do what we need to do? And I think every department in the country will say no. But we have got a significant increase in our budget in the last couple of years, and we've been able to, through budget advocacy, be able to at least expand our staff complements and get the core skills we need. I think a discussion that not only the NPA needs to have, but all prosecution authorities right now that are dealing with the kinds of complex crimes that we have to handle, not only safe capture, if we look at the future of organized criminality, is it's not just the nature of the skills that we need. It's not just the money that we need. We need to be able to bring in the kinds of specialized skills.
I don't think we've been here.
We need. This one seems worse. We need to bring in the kinds of specialized skills that prosecution authorities are going to struggle to find, even if we had all the money in the world. And that's why we've had to partner with relevant entities. We have to be realistic that some of the skills we need, the specialized forensic digital skills, are not going to easily come to government, which is why the initiative that we have now in terms of the engagement with the private sector is very important. But I think a fundamental question that needs to ask about, do we have the resources we need, is not about the money, but it's about the legal framework that we operate in. This question around giving the NPA back its criminal investigative powers that we've been speaking about for so long, that's really the key question. It's not about necessarily about money, it's about, do we have the legal framework to bring the skills back into the organization that we need, and do we have the partnerships in place to be able to bring them back in? And luckily, we've made a lot of progress in that regard, and hopefully in the coming months that will all come to fruition.
Thank you. Advocate Batohi, we're headed into a complex and shape-shifting election. Do you feel that there is sufficient independence of the NPA now, so that election doesn't matter really how power may shift politically, that there's sufficient independence for the momentum to really take off now?
I think the short answer is yes, and I think this particular, I think I can speak for the EXCO of the NPA, but certainly for myself. I mean, it doesn't matter who is in power post-elections. We are here to do a job, and so we intend to remain in office and complete our terms and do, So I hope I got your question, properly. But certainly, I think the foundations that have been laid in the NPA is one that is really, it's going to ensure that there's a level of resilience in the NPA. There's still a lot of work that needs to happen in terms of the legal framework, appointment processes of a national director. It's all part of the independence issue. So we're working hard at those aspects, and we're hoping that in the bill that's to be introduced in 2025, that will also be included there. But I would say there's sufficient independence, but there's still, there's a lot more that needs to be done. I'm not sure if any of the colleagues want to add to that.
Thank you very much. So last night, I'm not sure about you, but I was absolutely transfixed by the trial of the former US president and the Republican presumptive nominee Donald Trump, who's actually in court while he's on the campaign trail. When will we see the political linchpins of the state capture era sitting in a court and answering for the charges which have been made in the Commission of Inquiry and elsewhere against them? Is that a bridge too far? Because I think statistics certainly matter, and they're very they're important statistics you tell us about. But in the popular mind, this idea of nobody actually wearing the orange overall and going to jail for what we call the lost decade is a very real perception, and it's not easily tempered by any amount of data.
No, that's a very valid point. But firstly, let me remind you that our ex-president is before court. So it's not only Donald Trump.
For a very long
For a
time.
very long time, exactly. And we are fighting very, very hard to get that case moving. So, it hopefully demonstrates that often, once the matter's in court, it's out of the NPA's hands to get to the point where the case can be finalized. And this particular case, because of the Stalingrad tactics. But we have, as I said in my introductory comments, we have some of the most powerful CEOs of state-owned enterprises. I don't want to mention names, but the media and all of you should know those that are before court. It's the reason why Andrea Johnson got the Person of the Year award in 2022, because there were a number of really high-profile arrests that were made in that year. These cases are now in various stages in the court process, and I'll ask Andrea to come in on that. But I can certainly say that with the capacities and capabilities of the ID, permanent ID, as well as the capacity that business will bring to the table once that is done, I have every confidence that if we could achieve what we have done with very little, that the days are certainly numbered in terms of those that will be before the courts. Anton, you want to say something, or Andrea? Andrea, you want to say something? I don't know. I hope the mic is working.
So the NPA executive, if this doesn't work, I still have a court voice apparently, so let's go for it. Members of the media and my fellow NPA colleagues, I think straight off, I have to say I'm alive to your reality. I'm alive to the reality of South Africans and their expectations. What one must not do is downplay the expectation, but the reality of the ID currently, unfortunately, is we do not have criminal investigative capacity only because we are not yet promulgated into law as independent. It is the NPA Amendment Bill, once promulgated into law, allowing the NPA, for which the NDPP has now said we do have the resources, to recruit in terms of the powers we do not have. And so, unfortunately, ladies and gentlemen, I still have under 20 criminal investigators having to deal with all of the Zondo recommendations, the Nugent Commission of Inquiry, the Party Commission of Inquiry, and any other high-profile criminal matter in terms of corruption referred to the ID. They are not called excuses. It is our reality. Can we do more? Of course. Do I want to do more with my team? Most certainly. And I'm hoping that the permanency comes through sooner rather than later so that we can change the face of how we deal with corruption and the expectations of the country.
Andrea, can I follow up with you, if I may, please? So I think it was hugely deflating moments for the country when the first two big state capture cases appeared to fail so spectacularly. On the second one, where the ESCOM case, where Mr. Machela Koko seemed to obtain a real victory, it's now transpired that the magistrate Stanley Jacobs, in fact, was engaged in business activities with ESCOM. Is there any follow-up possible to that? And will you be re-enrolling that case? And also, are you able to share with us any other, I know you can't name them, but when might we see another significant state capture case?
So I've learned failure is relative. And failure is subject and open to interpretation, as has clearly been the case in the public domain. We did not fail. The Lulani matter is on appeal. And in the appeal process and in those court papers, it will also become apparent that in the state capture matters, I think what one forgot about is we've talked about capture of the police. We've talked about capture of various institutions, including the NPA. So when you go to court as an officer of the court, respecting the rule of law and expecting everything to go in terms of fairness and objectivity. That didn't turn out to be exactly the case as well in the Cocoa matter. And so, unbeknown to us, we must do what we must do. Always go in on good faith, building the case that we have. We did enroll on a prima facie case. We know we have a good case. Yes, we're going to re-enroll the matter. And with regards the magistrate, well, thank you to the media. We now have become aware. So yes, you do play a positive role from time to time. So we thank you for that.
Noted.
And it's important because it brought to the fore the reality that in the state capture cases, whether we like it or not, almost invariably the state will walk in with one hand tied behind its back, unbeknownst to itself. And so, no, we did not fail on the COPA matter. The matter will be enrolled. The issue of the magistrate is rather sensitive, but it is also rather worrying. So we are able to say that steps will be taken in terms of the relevant reporting lines. The outcome thereof cannot be dictated to by the NPA, but we will make sure that the matter is escalated as we have indicated to where it needs to.
You've complained to the Magistrates Commission. I don't expect an answer to that question. I do want to move on because I'm sure colleagues have burning questions to the idea of corporate alternative dispute resolution. In other words, 6 billion rand in your coffers. Advocate, how did you do that? 6 billion is a lot of money. What happens to it?
Okay, let me start with the last questions. What happens to it? And thanks for that question, and thanks to the media who's reported extensively on this. So what happens is that the money goes to the criminal asset recovery account, which is held at Treasury. And then it gets distributed by a committee of ministers to fighting back crime. So just touching on this ADR, and we're part of international obligations in South Africa. So legally, we have signed these treaties to be part of what is innovative ways of fighting corruption. There is no way in which, with so much cases that needs to be investigated, you would have been able to investigate sub-global sitting in Germany and we are sitting here. So we've encouraged companies to self-report, and indeed they self-reported. And we had a negotiated settlement. It was a multi-jurisdictional investigation in that the Securities Exchange Commission, as well as the DOJ and the USA, investigated the matter. Zondo Commission looked into the matter, SIU looked into the matter, the public protector looked into the matter. And then when it comes to a decision not to prosecute the corporate, it has to come to an end. And that's what we did. So there are two ways of settling the matter. You need to disgorge the actual amount that's taken, but you also need to pay a reparation, which is almost a penalty. That's the 750 million. So I think this is very good because if you look at what was tainted, you're looking at about 223 million. And yet South Africa has gained far more than that, 2.2 million. So I think this is a very positive and innovative way of fighting crime and making sure that we get the evidence that is going to enable us to prosecute. I would like to quote the private sector, the CEO of EOH, when he retired, I think recently in the media, he said, businesses are not corrupt, but it's people in the business that are corrupt. So what do? We have to prosecute the people who committed the crime.
So they make wonderful headlines, all these billions being recouped. It's fabulous, and obviously it means something. But aren't we just letting global multinational capital off the hook? They have lots of money. And so let me give you a few examples. SAP and ABB continue to work in our country. Shouldn't they be banned? Bain continues to work in our country. Shouldn't they be banned from doing so? The former CEOs of Bain and McKinsey, responsible for egregious corruption, have gone on to establish investment offices either in Italy or in New York. So there's no real justice being served here, I would argue.
I think justice is going to be served in the sense that, as we've said, we've got a two-pronged strategy. You need to get back the stolen money, but you also need to prosecute the wrongdoers. Those CEOs that have moved on are not the actual perpetrators of crime. It's the people that are still going to be prosecuted that are the actual perpetrators of crime. Businesses are not corrupt. It's the people within the businesses that are corrupt.
Thank you very much. Advocate Batohi? Oh, I think I'm so right. Just to add one point to that, and to also say that the businesses you mentioned, like Sam, I mean, can you imagine if we just stopped those contracts tomorrow, what would happen in this country? They would be, we don't even want to think about that. So we have to think about how do you ensure that a business is able to still render the services because there are people that are employed by a company, their service, but at the same time, they are actually being held accountable. The business is held accountable in terms of financially, and the people that are responsible for making that corporate do the wrong things are also held accountable in terms of prosecutions that will follow.
I don't want to be hard asked, but doesn't it mean that wealthy people can simply buy their justice?
Thank you very much and good morning to everybody present. Perhaps I just want to add to that. So we mustn't have the impression that this is just an open door for business or for companies. The criteria that they have to comply with before prosecutors make any decision to look at alternative mechanisms. So what we need to understand that this is a way of resolving the prosecution. So you have to balance it. You've got to weigh up what is the cost of taking a case to court, investigating that case fully, and what are the benefits of a settlement after the prosecutor has evaluated all the evidence against a particular company and then making a decision based on a transparent process where the company engages with the prosecutor or the state and says these are the conditions that we agree upon in order to reach that settlement. So it's not a free pass where any company can just come forward and say, I want to pay X amount of money. We don't work that. It will be based on a proper evaluation of all the evidence, what crimes were committed, what the company is prepared to do in terms of the reparation process, and what the company is prepared to do to assist the state with the prosecution of the actual individuals concerned. And we've got to remember that we want growth in terms of the economy. So it's important for us as the prosecuting authority to balance all of this in the public interest. And I think that is where we are.
Thank you for the explanation. Can you also speak about the Steinhoff case very quickly before we open to questions? You really seem to have assembled a crack team who is going to prosecute that case. Could you describe to us whether it continues now that the former CEO, Marcus Euster, took his own life?
Yes, the case will continue. The DPP office in Victoria and our specialized commercial crimes prosecutors in Victoria will continue with the matter in terms of the strategy that we've adopted in relation to Steinhoff. The work continues, the ongoing work continues in terms of preparation and the engagement with other jurisdictions in order for the state to be ready to proceed with the case. And we've also indicated before, potentially there will be other accused that will also join under that. So Steinhoff demonstrates accountability. In order for us to achieve accountability in our country through prosecutions, we've got to bring cases that are well investigated, well prepared, so that people can be accountable. In fact, accountability for the actions and the crimes that they have committed. So, in the case of Mr. Euster, I think the accountability caught up with him ultimately. And that will happen in all matters. It may take a bit longer in certain matters, but that's because we want to build solid bases.
Thank you.
I just want to add to that in terms of the crack team. I want to say that we got external counsel to assist just very recently what, 6 months or so ago. But I want to say that to the prosecutors themselves, who are a crack team in themselves, but nobody saw them as a crack team. The NPA was castigated for years about one of the reasons why we're useless is because the Steinhoff matter was also not being prosecuted. And this, I want to really appreciate the work of the prosecutors who quietly carried on the work in the background in the face of incredibly tough and painful criticism publicly about not doing anything. And the support they got from the external counsel at the end was really to make sure that we had everything, all the ducks in a row, and we were ready to go. But I really want to commend the prosecutors for the excellent work that they did in this matter.
Well appreciated. I think a few of them want to clap over there. Please do. Okay, we'll open for questions. Phalaphala, would you like me to take them? Or how are we going to run it? Shall we do one at a time and maybe identify yourselves, colleagues? Yeah? So I see Karen Moon, Peter Dutoit, and colleague in front. I think Mike's will come to you.
Sorry, budgetary constraints, we couldn't get more mics. So sorry about this.
Hello, Karen Moore from Newspaper. Am I correct in understanding that a few years ago the NPA got a legal opinion from Milton Epstein in regard to the level of legal reviews that you face from people who are challenging your decision to prosecute? And his suggestion was that you actually didn't have to postpone cases, that you could ask those accused people to simply get interdicts prohibiting the prosecution and go on with the prosecution. I don't know if that's correct or not, but I think one of your biggest issues is that you simply seem to take the view that if you are taken on review, the prosecution must stop. And we've seen that in Washington, we've seen that to extent with the Zuma matter, we've seen that in a number of the pro cases, and a number of those reviews end in failure. So what informs your decision to simply, in those instances, not say to the accused, you have to bring an interdict. You have to stop us from prosecuting you. And you've taken that stance in the Zuma matter. Billy Dana has taken the view that in that case, should Mr. Zuma attempt to appeal this latest attempt to force his removal, the NPA will push for that trial to proceed. Why are you not taking that stance in other matters? Because as Ferial suggested, with this idea that people with money can simply take your decisions on review, you have effectively allowed the NPA to push back by people with resources. Then the second question I have is just on the issue of the Gupta extradition on New Lane and on Corpo. I can understand your frustration, but the fact of the matter is that several very problematic findings were made against the NPA. The Corpo matter wasn't struck from the roll because of the NPA wanting to pursue it. It was struck from the roll because you had a data analyst issue where you had struggled to analyze data for close to a year. And that was the basis of the decision. The most fair rebuttal you can have in that decision is to put the case back on the roll and to prosecute. So, I think that is a resource issue. On New Day, I sat in that trial, and I can honestly tell you that prosecution was not particularly stellar. It was described by the judge at the end of it as a comedy of errors. You are attempting to appeal. The SCA has said it will listen to your leave to appeal. It hasn't granted you leave. But there were serious issues with that case. And on the Guptas, I understand what you're saying in terms of political will, etc. But the court also raised issues about the warrant. It was very concerned about certain factual dynamics of that application. So is there not a place for the NPA to look back and say, maybe we did make mistakes, and maybe we potentially need to be a little less defensive about our own part in the situation and realize that perhaps we could have actually got things wrong.
Thanks, Farrell, and thank you, Advocate Batohi and your team for this morning's engagement. While we're on Steinoff, can you perhaps, Advocate or Batohi, give us some insight into what it takes to bring a matter like Steinoff to court? It took a long time, you acknowledge that, but you could just give us some background into how difficult it was to conduct that investigation, given resource constraints, given the capability of the NPA to investigate complex financial matters. You referred to the German authorities that also struggled. So maybe just for background purposes, it would be good to understand how difficult it was to bring someone like yours to book, and certainly someone in the media that we waited for a long time to see accountability and judgment delivered to. Thanks.
Shall we take those two?
Yeah, we can take those two. On the issue of the abstain interdict, and I'll ask Advocate Kopp will deal with that. But I know one of my previous colleagues here who worked with me had that very strong view about the interdicts, and she often raised the issue about this. So it's not like we're not aware of that. But I'll ask Advocate Kopp to deal with that matter. And maybe you can go for that first. We'll take it from that.
So that is the correct legal position, Karen. The other one,
Hold it closer, I think.
yeah, the other mic is actually much better.
Oh, how you hold the mic?
I hold the mic. Yesterday, I had the opportunity in the meeting with the police. They were having similar problems, and they constantly passed the mic from one person to the other person. And eventually, I took both mics. I said, "No, we work. We keep both together." So we are aware of that legal position, and that is the legal position that we adopt in the country. What we must be mindful of is two processes of review. The one is in terms of the NPA Act and the Constitution, when an accused person has the right to review, to ask the entity to review a particular decision that has been taken in the case, or any aspect of the case, or the conduct of the prosecutor. So the law is broad. A review can be done to the entity. That does create delays, and we suspect that sometimes accused persons abuse the processes that have been put in place. Of course, we operate within a constitutional democracy, and the Constitution prescribes to the NPA how it operates. And so the process of review through the NDPP to the NDPP is something that we have to manage very carefully. It's a formal process, and we have to manage it in terms of the law. The reviews to the court is a different category. And it's a different type of abuse of process when accused persons repeatedly apply to courts for review. And so the general position is that prosecutors have to proceed with the trials. And that happens on a daily basis. We don't stop a trial, or we don't stop a prosecution because an accused person has launched a review. But what happens in practice in the criminal courts is that the accused to the court itself will say to the court that I have launched a review process. And the court often then indicates to the prosecution that we will not proceed with the matter. And so prosecutors on a daily basis are in the hands of the courts. But our position is that we will proceed with trials. And we've reinforced that position with all the directors of public prosecutions who are sitting in this room today, that prosecutors must argue that the trial proceeds, unless a court order is given. And remember, in a criminal court, if a magistrate or a judicial officer gives a directive, it's a court order. And if the court order is, we are not proceeding with the trial until this review has been completed, then the state is subject to that position. So we try our best to proceed with all cases, but of course, we cannot prevent an abuse of process, and we need the judiciary to be very strong in terms of how this is dealt with in our courts. And I think that some of the judgments that we have seen coming through is starting to set up jurisprudence that is really going to help the state into the future. So I think there's some goodness coming from it in that we're developing the jurisprudence and that we will get judicial officers, particularly in the lower courts, to be guided by the judgments of the high courts, and that we can get faster and speedier justice in our courts.
I just want to add something, but this is a very frustrating issue. And the issue of the interdict, I think we need to consider a bit more, in terms of, the DPPs are here, because this is not something new. And we've got to look at that. But, it's often the courts are not prepared to start the criminal trial whilst there's a review still pending in another court. So that's been a challenge. But then let somebody bring the application and let's test that. Because this is going to be, I think the Star and Grant tactic, in my view, is one of the greatest risks to the rule of law in this country. And so we really have to look at how we firm up our arsenal in terms of dealing with it in the courts. In terms of the issue of the problematic findings, the one thing I keep saying to my team is we cannot be defensive. We've got to understand and we've got to appreciate and we've got to take lessons where things, we've got to be open, frank, and honest about what goes on. And so it is regrettable that we come across as defensive, but the position is that with regard to the cocoa matter, it did relate to certain aspects of procurement and getting the necessary capacities that we needed to analyze lots of data. Let me put it that way. Petabytes or terabytes, I'm not sure what the right term is, but that was. But in that particular case, the magistrate could have made one of several orders. Several. It took the most drastic order of striking off, and we must ask the question why. Because he could have put the. And again, I want to be very careful because, as a prosecuting authority, we don't openly criticize. We are officers of the court, and we've got to respect the judgments. But in this particular case, it is a fact that various orders could have been made. The most drastic one was made, and now there may be an understanding of why that was the case. But of course, we've looked at this between Anton and Andrea. They've looked at lessons learned. What could we have done better in this matter to ensure that we are able to get the expertise externally we are trying to procure in order to get this done faster. On the Nule matter, that was probably one of the most scathing judgments I've ever read in my life. And many people have said that. It's a bit difficult when you're dealing with, when you think about what I just said about not talking about the judiciary, it's very difficult. But of course, we looked at, what could we have done? There've been lessons learned process after that, and Andrea can talk about that. What did we do? What could we have done better in this matter? And how do we learn from this? How do we make sure? Because these cases, we more than anyone know the risks that these cases are to the NPA. And we cannot just say, well, we did everything fine. There's nothing we could have done differently and blame everybody else for it. We have to have very hard, difficult conversations with ourselves to make sure that we learn from what went wrong and that we make sure we put in place interventions to make sure that the risks of that happening again are minimized. I don't know, Andrea, if you want to add anything on that aspect. Andrea?
And that's to say, trust me, you know me, we take it on the cheek and we cannot be flippant about it. You would have loved to have been a fly on the wall at Linton House where the ID is housed. It really was not a pleasant week for those who were in court. The truth of it is, in as much as one wants to say, how does a presiding officer arrive at a comedy of errors? You have to look at what went on. And so we did. In fact, we didn't just do an internal review. We handed the judgment to colleagues, senior colleagues within the NPA, asking them to critique us about where they think we went wrong, even though we could see if we went wrong, what we could do better. And we have taken lessons because that is the reality. You can't have a repeat. but you will have a repeat if you do not have that internal introspection and really, really difficult discussions with the team that was involved. With the COCO matter, I think the biggest lesson was these matters do take long to prepare. And I think the challenge might have been, do we know exactly how to quantify the length of time? Not because you're doing anything you shouldn't, but that was the reason. The data analysts had really large volumes of data to analyze. And I think that going forward, that was the lesson that we needed to learn. With the Guptas, I know that one would want a better answer than the one I'm going to give. I can only give you the honest answer. I know everyone says it's about the warrants. We've been to the UAE, myself. We've asked the Ministry of Justice, as well as the judge of the Central Authority. They did not give us the reasons. We've written various note verbals asking for those reasons. They have not been forthcoming. And that goes to the point that the NDPP made about us asking for a different intervention. And also, it would be easy to say, why don't you resubmit your application? Of course, we would love to. But there's an issue of concurrent jurisdiction, which means, can the UAE tell us whether or not they will prosecute the Guptas for money laundering in their country? Because that changes the face of the extradition application should we need to resubmit. That answer has unfortunately not been forthcoming. So please, we will certainly not defensive, and we really have to take what has gone wrong on the chin. We have gone wrong in certain instances, and we can only try to do better.
John? Sorry, did you want to
come back
answer
to Zondo?
the next one?
I just want to make a point to the media, and we have this engagement a lot. And as you know, I also speak to many of you on a regular basis. The one challenge we have as the NPA is that we can't engage on the merits of certain matters while we are litigants in those matters. So there are certain things we'd like to say. We, of course, are very worried about the slipping confidence in the rule of law. We're very worried about the narrative that the NPA is not succeeding against state capture. And that's why briefings are like this are very important. I think there are two dimensions to it. The first dimension is there needs to be a balanced understanding that while there might be frustration around the state capture progress, I think the points that the National Director have made around the progress in rebuilding is vitally important for South Africans to understand, not because we're trying to protect our legacies or our jobs, but because it's a fundamental component of the rule of law in this country. As you know, that's the thing that binds the social contract together. So we want the public to understand that there's a lot of good going on, but we are in a difficult position when it comes to complicated matters. There is at least 2 hours worth of information we could give you on what's happening in the actual live cases that we're dealing with, concerns we have about certain aspects of judgments, concerns we have about certain conduct. But we cannot unfortunately speak about that because we are litigants in those actual cases. So it does put us in a difficult position. But I also want the media to understand that at the right time, we will come out and explain some of these things. But it's not about being defensive. It's just, it puts us in a difficult position as litigants in live cases where we actually can't say some of the things that you can get your sources to speak about. We as the leadership of NPA are in a difficult position. I think all prosecution authorities face that challenge.
Thank you. So on the question of start-off and the investigation itself, as we know, these investigations are very complex. A company like Start-off was listed internationally. It spanned multiple jurisdictions in terms of the assets it had gained in other countries all over the world. And when the criminality was identified, it of course meant that a forensic audit had to be done. So within Start-off itself, there was an internal forensic audit that revealed the criminality. And that of course became the basis upon which a police investigation, and remember, in this case, the DPCI was the investigating authority, not the NPA. And so we partner with the police through our prosecutor-guided investigation methods to assist with these complex investigations in commercial matters. And so all of those factors, the forensic audits, the multi-jurisdictional nature of the crimes that are committed, the mutual legal assistance applications to different jurisdictions, to get those jurisdictions to cooperate, to gather the necessary evidence, all of this takes a long time. And of course, in today's language, you talk about terabytes. And of course, that is why we need digital capacity, forensic capacity in today's world to be able to analyze that information and to convert that information into evidence that we can place in a coherent manner before a court. That is hard work. It doesn't happen on its own. We have to find that evidence and build that evidence. In my day, when I started out, we didn't talk about digital evidence. We spoke about rooms full of boxes with files and files and files, and many prosecutors know that. So a case like Steinhoff is a case like that, where you have 2 or 3 rooms filled with boxes of files, paper, and this is the evidence that has been collected. So it was a very big project for the prosecutors.
Thank you very much. Fascinating insights. Yes, ma'am? Any questions?
Okay. Hello. Hi, I'm Jana Marksman, producer for Carte Blanche. Can you hear me clearly?
Yes.
Cool. Has the NPA, and I think this question needs to be asked to the Department of Justice as well, but has the NPA received unrestricted access to the Zondo submissions yet? And if not, what is the delay? And I also want to ask if said restrictions, how that is affecting your ability to investigate. I understand that all the submissions that was presented at the Zondo Commission, also those that were submitted but maybe not handled on the floor due to time constraints, are all held in a library that's with a supplier that the Department of Justice got, and that the ID needs to request information if they want to get hold of the evidence taxpayers paid for. So yeah, I want to know what is the situation there, and why isn't the ID that's been mandated to investigate state capture cases not getting unrestricted access to evidence?
Thank you, Jana. Just pass the mic behind you, please.
Thank you. Good morning. My name is Moluko from ENCA. I'm just seeking clarity because I'm getting conflicting messages here. On the one hand, you are appealing that New Lane investment judgment that you admit was scathing. Yet, you remember are just giving us an impression that you reflected on the presumably the shoddy work that you possibly realize as the IT, considering the fact that indeed, despite the fact that some of your investigators, they have LLBs, emerged in court, some of them have qualifications in forensics, but the evidence that was led there, it was, in some instances, you wondered whether people knew what they were doing. So it didn't come as a surprise when that particular matter was dismissed in that manner. What I want to understand is what specifically is your position? Is your position the fact that you still believe that the judge was completely wrong, or you admit that you also had shortcomings there? While on that, I want to understand, seeing that the Deputy President is in the UAE, what specifically do you want him to do in terms of the political intervention that you require? But somebody's going to ask, what's the point of insisting on bringing back the Gutas? When, as matters stand, the impression we are getting is that the ID or your investigation capacity really isn't up to scratch. And having seen how that case of New Lane, a company owned by the Gutas, how it fell, bringing them here, what confidence on the basis of the investigations that you've already done? Why should South Africans believe that you will really get to do a good job there? But I also want to understand, because you are saying that you do work in partnership with other investigating authorities, the Directorate for Priority Crime Investigations that we know are investigating the whole Phalaphala issue. Yes, on the one hand, there are people who are before courts, but those are just a small fish, if we are honest. There's an issue of money that was found at the president's property. We don't know how that money was there. Somebody would think along issues of money laundering. How far, when you are interacting with the homes, how far is that matter? Is there hope that somebody will ever account, not for stealing the dollars that were in the sofas, but account for the money that was found at the president's house?
So maybe just to take those on the new lane, I just want to clarify, when I said the judgment was scathing, I meant not scathing in terms of I meant the language used, but not talking about the legal issues and the merits. So just to understand, when I use the word scathing, I actually referred to language like comedy of errors and other very, very, harsh language that I hadn't heard in judgments before. But I was not speaking about the merits. So just to be clear about that, and that matter, of course, is on appeal, and as Andrea Johnson has mentioned, in terms of whether there were mistakes and issues in terms of how the prosecution could have done things differently, they've gone through a process to ensure that if there were any shortcomings on the part of the prosecution in terms of how the case was managed in court, that those are addressed and that we don't have similar challenges or issues in other cases, particularly related to state capture. With regard to the issue of the what do you expect the DP to do? Well, the reality is that we are of the view that there's no. I was asked this question in a previous interview about whether the UAE is cooperating with us, and I kind of said we have challenges, and I left it at that. I think maybe I can go a bit further and say I'm not sure if there's any willingness to really assist South Africa in this matter at a technical level, and I'm not sure at a political level, because mutual legal assistance ultimately, although it's a technical process, but it depends on political will. And if the leaders in a country do not want to cooperate with you, there's no way you can get that cooperation. So what we hope the DP will be able to do, we have briefed him fully on what we're doing, and really is to get the commitment from the rulers of the UAE at the highest level for them to understand the importance of these cases to South Africa, and for them to get the commitment at the highest level that the UAE will support South Africa in our requests, whether they are, and it's not just extradition, there are various other requests for evidence that we have sent or in the process of still sending to the UAE. DK, on the deal with the
So I think that on the question of the merits of particular cases and investigations, we are not going to comment on any live case and investigation. I don't think that is our thing to do, and that is not the purpose of this briefing, that we are going to cases where we still need to make decisions. So I think in fairness to the processes and in fairness to the investigating authorities, and the majority of our investigations are being done by the DPCI, we have to wait for those processes to unfold. We have to wait until investigations are concluded. We have to wait until prosecutors have evaluated those individual matters, and so that there can be a fair process. And whatever we decide is transparent. Whatever we decide can be taken on review, and it can be dealt with in an appropriate forum. So I think we need to have confidence in our institutions, and we need to have confidence in the ability of our prosecutors to do their work in an unbiased way, and taking into account that each and every prosecutor in this country, including the ones on this podium, have taken an oath of office and have sworn that we will do our work free of prejudice, free of fear, and we will do our work correctly. So I think let us accept that the work is happening, And when we are ready to make decisions, we will make decisions based on the evidence that's contained in the investigation.
If I can just add to that, firstly to say that in the past, prosecutors did take an oath of office, but they didn't do what they were supposed to do. So we do take an oath of office, but as I say to all prosecutors, our work must speak for itself. That saying that we take an oath of office, and it's an important issue, I don't mean to underplay that, but our decisions must demonstrate that we are independent. Now, I want to make the point that some often people misunderstand how decisions are made in the NPA. The directors of public prosecutions in each province have the legal authority to make decisions on cases. The national director does not make decisions on cases. I want to make that clear because I think even the public thinks that it's the national director who makes decisions on cases. But of course, yeah, when things fail, then the national director must take accountability because you are the head of the institution. DPPs work under the control and direction of a national director in terms of the act. So yes, you can ask for reports, you can give guidance, and you can, you can actually instruct, provided you don't tell a DPP what decision to take. That is their decision, their legal authority to take a decision in a case. This particular matter is with the DPP in Limpopo. As with most high-profile matters, we get reports from DPPs on progress in investigations to make sure that cases are moving. But ultimately, when the DPP in a division is satisfied that a case is properly investigated and he or she can take a decision in it, they will. So that's about as far as we can take that question.
Will you answer the Zondo archive question?
And I take it that question will be asked very loudly as well to the other persons in the criminal justice value chain, because you do hit the nail on the head. We do not have unfettered, unrestricted access, as is the expectation in the country. And so one therefore says, where we are currently, we're working with what we have. And one would have wanted that unfettered, unrestricted access. We currently work on the basis of issuing a subpoena to the existing Zondo staff, waiting for a turnaround time, awaiting those documents. When if you had that unfettered and unrestricted access, and by the way, the NPA has been kind enough for us to have onboarded some of the Zondo resources. That notwithstanding, we still do not have that unfettered and unrestricted access, and that is critical. And I think that the expectation out there that the ID, being the arm that has been set up to do this work, actually is not doing its work, even though it should and must actually have access, is actually a myth out there. Just two last things, and I think I would be remiss if I allowed the contention that it is the ID who's got investigators that are overly qualified in doing shoddy investigations. The overly qualified investigators in the ID space currently are our financial investigators who are not the criminal investigators who deal with matters. And we have, in the New Lane matter, our matters are being investigated by our counterparts in the DPCI. So we take all those criticisms as well because the matter is with the ID. What the ID is not going to do is throw a partner under the bus. There's no conflicting messages about what we think about the court. I think it is clear. We're saying the court did get it wrong in terms of fact and law, and I'm going to leave it at that. Hence, the application for leave to appeal.
Thank you very much. Shall we take a last round of questions, colleagues? Okay, so to anybody who hasn't had a chance who'd like to ask again. Sizwe Mpofu Walsh. Okay, and there's questions on the WhatsApp group.
Thank you very much. I'd like to ask two brief interrelated questions. The first is about the State Capture Commission's report. And it seems to me that the report has left you in the worst of all worlds in some ways, because it's raised serious public suspicions about senior politicians. And then it's left the NPA holding the bag to prosecute those cases without actually giving you prosecutable cases. Do you feel frustrated with the way that in some ways it's been handed over to you now and there's now great public pressure through the report, and yet not sufficient evidence to meet the standard for criminal prosecution yet. I wonder if you could comment on that. Second, in terms of the Phalaphala question, the response was that you won't comment on live investigations. Does that mean that this is a live investigation currently? Thank you.
I think maybe I can start before. Just on Phalaphala, yes, the matter is being investigated. It's a live investigation. And the second one, Andrea, just to say that the reality is that the Zondo Commission did not give the NPA a blueprint for prosecutions. And in as much as it was a really important process for the country, hugely important, it did raise expectations unreasonably that prosecutions will follow very, very quickly from that. The standard in a commission is a balance of probabilities. There are people that come and can testify, give hearsay evidence, say what they want to. That's not admissible, may not be admissible in a court of law, where you try to prove a criminal standard. Besides all of the, the technical, the evidence, the Gupta leaks, etc. We need to prove the admissibility of every bit of evidence. So that has been, you're right, it put a lot of pressure on the NPA because of the expectation and maybe the misunderstanding that Zondo actually gave a blueprint for prosecutions, which is very, very far from the reality. And Andrea can talk more about that. Andrea, no, it's good.
Thank you. I'm just going to take some online questions from Fresh Voices and come back to Peter and Moloko. Thank you.
Thank you, Feria. NDPP, we've got two questions. One reads as follows: what steps are being taken against Section 204 in the Nakula matter to recover the proceeds of crime? I think it's an AFU matter. The second one is from Jan Korojo from News 24. It says South Africans have been duped by alleged complex cryptocurrency scams or pyramid schemes, such as Meta Trading International, M, BTC Global, and others. When can we expect arrests and prosecutions linked to cryptocurrency scams? And is this a priority for the NDPP? Thank you.
And then shall we just wrap with Peter and Moloko, second round? Thank you.
Thank you. Advocate Johnson, just one quick one. About a year or so ago, one of the country's most prominent liquidators, Tuta Murray, and his son Thomas, was killed on the N1 North. You know very well that he plays a big role in seizing assets. Is that something that you are looking into, discussing with the DPCI? How concerned are you about that? And then just one last point to Advocate Batohi, just to get back to the issue of independence. The NPA, the history of the NPA is fraught with problematic relationships between the national director and the head of state, whether it was the dismissal of Vusi Pikoli in 2008, whether it was the appointment of a series of NDPPs during the years of state capture. How would you characterize your relationship with the president and that of your office with the office of the presidency in the context of your remarks about independence? How would you characterize your relationship with them? Thank you.
All right, Moloko again. I don't think my question about the significance of bringing back the Gutas here was responded to. I think I can also add to say, have you concluded all your investigations regarding them, or given the fact that your capacity, as you have been saying, is not at a level where you are happy, or are you still going to proceed with the investigations? Earlier on, while on you, Advocate Jensen, this is how I understood you to be saying, correct me if I missed it completely. When you were giving context of the extent of the capture, you sounded as if you were even suggesting that the courts are also captured. Sounded as if all the facets were captured. And if you look at the fact that you are so unhappy as the NPA with the Coco matter as well as the new lady. Are you intimating that perhaps those judges, the judge and the magistrate, perhaps could have been captured? I want to then ask about when you were opening, ma'am, Advocate Batohi, you pointed out that there was so much pressure when you started. If you can just outline specifically what was that all about, where did it emanate from? Of course, earlier or later I heard you saying that there was never any political instruction. And lastly, I want to ask about the TRC cases. You received a legal opinion from Advocate Nsavez, who recommended that there must be a commission of inquiry to look into allegations of political interference previously that could have led to those cases not being investigated. I know you also deposed affidavits, former advocate, National Director of Public Prosecution, Prosecuting likewise. Having spoken to the Minister of Justice to ask whether such a commission of inquiry will ever be instituted, he was non-committal, saying, with the money that we have, should we investigate, find out who interfered, or should we give it to the NPA to continue doing the job? On the basis that you are the one who commissioned that particular legal opinion, what is your point there in order to at least salvage what is left of the reputation of the NPA as far as all those allegations of political interference are concerned?
Okay, so to start with the two online questions is, will there be asset forfeiture recovery from the speaker? And then secondly, what makes our cryptocurrency scams? And then I'll get to Peter and will cover his opinion.
I'm not sure where the mic is. Just this one. Or the other one. This one working. The witness section.
Yes, thank you very much for that question on seizing assets of I thought the question was the section 2 for witness. Yes. So as AFU to go out and seize assets, you can wait until there's a criminal prosecution, then it's conviction-based asset forfeiture proceedings, or we can go non-conviction based, which is not waiting for a prosecution. But in all of them, there are legal standards to be met. So first we need a referral where clearly there's a clear audit of financial flows that shows either the 204, section 204 witness or the speaker has benefited. So for non-conviction based, I need clear jurisdictional, I need to meet the clear jurisdictional requirement that there are reasonable grounds to believe that these are causes of crime. So that's the standard I need to meet before I go to court. The second bar I need to cross is that because we go expanding, we don't set the papers on either the speaker or the section 204, as it may be. I need to disclose all the material facts before the judge can grant the order. So at this point, I think it's early days for investigations. We haven't gotten a referral as yet, but as soon as we have, which shows that standard that we have to meet for non-conviction based, it's where there's a prosecution already, the standard is much higher. We need to wait for the finalization of the criminal case, and then we do an inquiry in court to show that there's a benefit from crime.
Thank you very much. And the cryptocurrency question.
Thanks. I think just I think the couple can add if necessary. Just to say, look, this is the whole area of cybercrime and cryptocurrency scams. It's exploding at the moment, and it requires these cases are all investigated by the DPCI, and it's part of the efforts to build capacity and capability. Firstly, to start off in the police to be able to investigate these matters. And then also for us, we have various training sessions, etc., for prosecutors to ensure that prosecutors have the necessary skills. But these are the types of specialized skills that we are at the moment rebuilding in the NPA. And with regard to the Murray and Thomas case, this is it's a chilling case, and it's very worrying, it's very concerning. It is being investigated by the DPCI. I'm not sure if Dr. Cock can take that any further, but we really need to deal with these cases as a matter of priority so that we send the message out that those that are working in this space are not at risk. And the longer it takes, and if we're not able to bring people to justice in these types of cases, it emboldens people to say that the system's not working. So, it's really up, the DPCI, is investigating this matter, and we hope that there will be a breakthrough in this, but it is a high profile matter and very concerning. The independence issue, how would I characterize my relationship with the president or the office of the president? I would say it is one that is very respectful of the independent authority and of a national director and the National Prosecuting Authority. The president, as I said earlier, has always respected that, been very supportive in terms of the work that we need to do, but never ever at any point has he said or done anything that made me feel that he was encroaching on the independent authority of the NPA. So I'd say it is one that is very respectful of the independent mandate of the NPA. And likewise with the Office of the President, to the extent that we engage with them, we have not had any issues. And I'll expand it to the Minister as well. That has been absolutely the same. The issue of the significance of bringing back the Guptas, I think for us, it is really important that when we do lodge a new application for extradition, that we have many more cases that are ready with regard to the Guptas than the two that were ready when we brought the original application. And so I know Advocate Johnson is working really, really hard to make sure with the team that we are putting together, I don't want to say too much because processes have not been completed, but we're seeking to actually get additional capacity from the Zondo Commission to work with us to make sure that we are able to actually proceed with speed on these investigations and to make sure that when another application for extradition is brought, that they are not just more cases, but that they are very well investigated and solid cases. So there's a lot of capacity, capabilities, new capacity that's been brought into the ID to deal with that. And of course, the capacity of business to support us will also help in that process. But we are acutely aware that it's critical that we do that. The pressure, sorry, I hope I didn't confuse. The pressure was certainly not from any political pressure, but it was just pressure on the base of the expectations of the country that the prosecuting authority, remember at that time we didn't even have an ID. It was working with the police and other law enforcement agencies. The pressure that people that are responsible for state capture would be brought to book with speed. And it was almost as if that appointment of a national director would just wave a magic wand, and cases would be just flowing through the court. And I think it was that pressure to deliver on the expectations of the people, particularly on state capture related matters, that I was actually referring to. On the TRC matter, we had a report from Advocate Nsibeza. It does recommend a commission of inquiry. That, as you are well aware, is a matter that's completely in the hands of the executive. The NPA did what it needed to do in appointing Advocate Nsibeza to look at what the NPA has put in place in order to address the atrocities committed during the apartheid era. And I dealt with some of that in my introductory comments. And all the DPPs are here. And Dike, I think maybe you will also be able to say something if you want to add to the TRC matters. But we are really on the Commission of Inquiry. It's we've sent the report to the minister, and that will be something. But we continue to ensure that the investigations are done with the DPCI, and that if they're inquest, we make decisions on these matters. As you know, they're old, they're complicated, and particularly with regard to the evidence, the witnesses are dying. We understand the urgency to deal with it quickly, but given the age, these are very, very, and other challenges, they are very, very complicated issues. But we're doing what we can to go, and also importantly, keeping the families informed of what is going on. That is one of the challenges. That was one of the challenges, but we're making sure we have regular engagements with the families to make sure that they are aware of the processes and where we are on the status of investigations.
Thank you very much. We're at time. Thank you so much for this act of open democracy and open communication. All our questions answered. Thank you, colleagues, for great questions, and mostly to the NPA staff who labor quietly and often unseen. Your work is recognized. Thank you so much.
Sorry, she hasn't responded to my
Which
question.
one? Courts captured.
Courts captured, yeah.
Courts captured.
Oh,
It's very
that.
important.
We can't have Moloko go home without at least one question being answered. And I want to say straight off the cuff, one can never afford, being officers of the court, to make such a generalized statement. And there is no such generalized statement. We've got to take our matters one by one. And the matter, if you take in the COCO matter, what we're saying is, unfortunately, there were certain things at play that we were not aware of. So even if you're suspicious about how could this have gone wrong in the manner that it has, and when the media came to the fore with some of the allegations which have now been investigated, you say to yourself, well, we've always got to be circumspect, but still believe that the rule of law is there and that all the arms come in to do the work they need to do. So, Moloko, we can't say the judiciary is captured. I do not have proof. And even if I had, apparently, I can't give it to you.
Yeah, we're not saying that.
Brunella. This one.
Thank you very much, members of the media. Thank you very much, EXCO, NDPP and the EXCO, for this very refreshing engagement with everyone. We've come to the end of this session. I believe everybody's questions have been addressed, and we will still continue to